This is Diesel for We the People. I just found this and I thought it'd be interesting for y'all to check out.
Sure. Okay. I do a show called the No State Project. It's where we're looking to get to a volunteer society, have a complete abolition of the not just government itself, but as a concept, as a legitimate concept. And so one of the things that I do is I have a lot of people in court, and there's you agree with the generalization that the laws and the Constitution, the laws of the United States apply to everybody in the United States?
I think that's accepted law, yeah, and it should, and obviously it should if you're within this geographic area and you're a citizen, and the constitutional rights devolve to each individual citizen.
Okay, so what actual evidence has a prosecutor or a plaintiff counsel ever brought to you to actually prove that the Constitution and Code apply just because someone's physically in North America, this part of North America, let's say Phoenix?
You mean without proving that they're a resident? Well, I'll see if I follow this. The question is, do prosecutors present evidence that the constitutional provisions apply to individual defendants? I think it's a presumption.
It's a presumption, but is there any, I get that. I've had federal prosecutors telling me, Norman Smith in particular in Oklahoma, who, when I asked for any actual evidence in the Constitution and laws actually apply, there's any jurisdiction over me, just because I was physically in the United States, he just thought it was a given. Or, like you saying, like it was a presumption. I've had the prosecutors tell me, well, it's the law. But is there any actual evidence that a prosecutor would be able to, should give to convince a reasonable person that the Constitution laws actually apply, just because, let's say, I'm physically in Phoenix?
Yeah, that's a legal question, not a question of evidence. So, for instance, let's say you're in Phoenix and you're alleged to have committed a crime here in Phoenix, and then you're taken in front of either a federal court or, depending on what the nature of the crime, or a state court in Arizona. The issue of whether or not the laws of the Constitution apply to you is a question of law, not a question. I don't know what evidence. The only evidence would be you are here, and they will put on that evidence. There'll be somebody. They do have to prove that a crime was committed within the jurisdiction, and they'll do that.
The question is, and it gets into kind of a circular loop. The question is one of evidence. So it turns out, is the law being applied arbitrarily, or is it being based on actual facts? So what facts would you use to prove that just because I'm physically in Phoenix, that the Constitution and the United States Code apply to me?
You're mixing a factual and a legal question together. The factual issue is, were you here? And that can be proven, and that evidence has to be proven, that you were within this jurisdiction when the crime was committed. The second question you're asking is a legal question. That is, assuming that you committed a crime within the jurisdiction, does this court have jurisdiction over you? And the answer to that is yes. And they don't provide evidence to that effect. That's a matter of case law and statutes.
So it's just circular. The law applies because the law said so, or the law applies because a judge like yourself said so.
Well, the issue of personal jurisdiction, which is what we're talking about.
Well, it's an issue of subject matter jurisdiction and personal jurisdiction. And it really begs the question, because the generalization is whether I'm committing a crime, accused of a crime or not. The fact that I'm physically in Phoenix, that means the Constitution laws apply to me. So to back up that argument or that generalization, what evidence is there to actually prove that's true?
You keep talking about evidence that that's true. That that's true is a legal conclusion, not an evidential one. But for instance, how could you couldn't provide evidence the other way, too? There's no evidence one way or the other related to the issue of whether or not the Constitution and laws apply to someone who commits or is alleged to have committed a crime within a particular jurisdiction. That's not an issue of evidence. That's an issue of whether or not there's personal jurisdiction. The answer to that is yes, but the factual predicate does have to be proven. They do have, in every crime, they have to in order to get jurisdiction over you, they have to allege and prove that, in fact, that you committed the crime within that physical jurisdiction. That could be done by your own admission. It could be done by a witness. It could be done by a photograph, etc. But that has to be presented. If that's not presented, then the case can be dismissed.
But it still begs the question, why are you under the impression, or have the opinion, the legal opinion, that the Constitution and laws apply to me just because I'm physically in Phoenix?
It's not just because you're here. Well, it is just because you're here. Because that's the scope
of the
Constitution.
But how does the Constitution apply to me just because I'm physically in Phoenix?
Well, I I don't know what you mean by just because. That is in fact,
the argument.
That's the key piece of evidence. That's what it pivots on.
But where is out? Explain exactly the facts, the mechanism that prove the Constitution applies to me just because I'm physically in Phoenix.
Okay. Again, that you're mixing an evidential issue with a legal issue. The evidential issue is, were you here? And again, they have to prove that.
But why?
Why? Because...
Why is that true? What I'm getting at is, I can say that this piece of paper applies to you because you're physically in Phoenix. And if you say, well, what evidence do you have that applies? Oh, no, you're mixing the two up.
You are, because this is because as I was mentioning earlier in the speech, we have a court legal system that has a monopoly over the adjudication of disputes and criminal matters within a specific geographic area, the United States of America. If they couldn't prove that you were here, let's say you were hauled into court here in Arizona, and the allegation was that you murdered somebody in France, then you get to say, wait a minute, how does the Constitution apply to me? I was in France when this murder took place.
Well,
that was the victim.
Well, actually, that's not true, because Blackmer versus the United States makes it very clear about the jurisdiction issue, personal jurisdiction. It also begs the question that how does somebody violate the copyright laws when they've never left New Zealand or they've never left Australia? So the physical location is not, because they're being accused of violating it. But it's still, the generalization is that if I'm physically in Phoenix, the Constitution, the laws apply to me, whether I'm accused of a crime or not. My question still is, what actual evidence is there to back up that generalization and prove that, Mark, just because you're physically in Phoenix, the Constitution applies to you?
Okay. Again, it's not a matter of evidence, it's a matter of law.
So it's arbitrary.
Arbitrary in the sense that all laws are arbitrary. In the sense that it could be different. We could have a system that said that you don't have personal jurisdiction over anybody unless they're wearing a pink hat. And if there's no allegation that you're wearing a pink hat when you committed the crime, therefore there's no personal jurisdiction. That could be a law. It could be a silly law, but it could be a law. And would that be arbitrary? You bet. Instead, we have a law that says if you are here...
If you... I can back up?
I sort of lost my train of thought.
If it is arbitrary.
Yeah. So, in that sense, the pink hat rule that I just came up with is completely arbitrary. It could exist. That could be the rule of law in a particular jurisdiction. Be a strange rule of law, but that could be it. Instead, what this country, and to my knowledge, virtually every other country, says is that when you're within the geographic description, the geographic areas as to which this Constitution or the laws apply, then you are subject to that constitutional law.
I agree, but other than your say-so as a judge and the say-so of other judges, is there any actual evidence? And I think you've already answered, it's not an issue of evidence, it's a matter of you said so.
Of law, yes.
You said so.
Well, not just because, I could vaporize tomorrow, but I'm still with all.
But that's because people like yourself, federal judges and attorneys and prosecutors, because they said so.
And legislatures also. Oftentimes the laws are written expressly stating that conferring jurisdiction over particular people, places, etc.
Because they said so.
Because the law says so. That's right.
So the question that I had for a federal prosecutor was that if he had no evidence to prove the Constitution and laws apply in the first place, that it was just arbitrarily done because we said so, then how do you prove beyond a reasonable doubt that somebody violated the law if you can't prove beyond a reasonable doubt that the law, applied in the first place?
Right, and the answer is that the issue of the law applied in the first place, beyond a reasonable doubt, the issue is, were you here? And not the issue of whether or not the law applies to somebody who is here. That's a legal conclusion that is subsumed in the whole notion of the Constitution and a set of laws in a monopoly legal system within a particular geographic area. So that's the given.
It's a given, so that's an issue that I've had.
I mean, there's cases on this, case law on this, but
those are just opinions.
Well, of course they're written opinions of courts.
Right.
That's what we call the law.
But the law is just an opinion. What you're saying is that when you as a judge make a determination, it's different from when I make a determination because it's considered a legal opinion and that there were men with guns that will actually carry it out.
That is one of the ways to define law also, but that's true enough. But you have to recognize the futility of making that kind of argument to a prosecutor or somebody within the system, because what you're really saying is, hey, this whole system is arbitrary. This whole legal system that you've concocted here, and therefore, where's the evidence that it should apply at all?
Sure.
And if the answer to that is, oh my gosh, he's right, then everybody just gets down to the judge takes his robe off and everybody goes home. And
that would be great.
In this whole legal system. You may think that would be great, but we haven't got to that point yet. So when you're within the system arguing, those kind of arguments have no weight.
Well, actually, it's not an argument. It's just a question. All I'm doing is putting forth a question of evidence, and based on what you've told me, that yes, it's because someone said so, you said so, or these other guys said so. So a lot of times we do have prosecutors realize they.
But you knew all that before you asked the question.
Well, that's true. You're just the first federal judge I've been able to speak to and be able to do this without fear of being thrown in jail for contempt. Because
I'm not going to hold you.
Well, that's why I'm doing this. We have had things thrown out. There were times, many times, the prosecutors realized they don't have a leg to stand on. Because the other thing, too, is the prosecutor, as not a witness or a party, has to rely on witnesses with personal first-hand knowledge.
Correct.
So where would the prosecutor have a witness with personal first-hand knowledge that the Constitution and law apply beyond a reasonable doubt?
They would have a witness and hopefully evidence to prove that you were here. But they don't have to prove that... They don't have to prove legal principles. All they have to do is make reference to the law or to opinions and prior rulings about personal jurisdiction.
But that's not...
They don't have to call the other judges as witnesses, for
instance. Well, no, because that's not what's happening. Because when you're talking about a legal opinion from a prosecutor or, let's say, an IRS agent, that if they don't have personal first-hand knowledge of the application, because if you're being accused of violating a code, which is what they're doing, let's say with the IRS, an essential element of that violation would be the applicability of the code. And as any element, even Norman Smith admitted that as an element of the crime, it has to be proven beyond a reasonable doubt.
Yes.
But to prove it beyond a reasonable doubt, you don't do that with political...
But jurisdiction is not an element of the crime. But jurisdiction is fundamental even beyond the element of the crime. They have to have personal jurisdiction.
But there's no crime without the code. So when you have a mala prohibita, for example, the applicability of the code is an element of the crime. Because without it, there is no... It's only a crime because some legislator, some lawmaker, if you will, said so. So being an essential element of the crime would have to be proven. And I've had prosecutors admit, yes, of course the law applies, and yes, it has to be proven beyond a reasonable doubt. But it's a given. And that's where we disagree, where I don't believe it is a given. If it is your opinion and your argument is that the Constitution laws apply just because you're physically here, it should be based on evidence, not mere circular logic. Well, it's the law because we said so. Or let's say,
it is the law. Your argument, the problem with your argument is it goes too far. No one's going to accept that within the system because, as I say, everybody would just, oh, well, I guess all law is arbitrary. We'll just fold up our tents and go home. Your case is dismissed. Oh, and by the way, the other 10,000 pending cases are also dismissed because we have no jurisdiction over anybody. As I say, it proves too much. No one is going to accept that.
Well, you're looking through it through your eyes as a libertarian. The average prosecutor is going to forget my name 2 minutes after I walk out of the office and they've dismissed it.
No, but any judge who is presented with this argument is going to think that.
Well, it's not an argument. What we do is we present a question that the prosecutor hasn't presented the evidence. We want to see the evidence of jurisdiction.
Well, who are you presenting this question to?
Well, we're usually initially to the prosecutor, and then we present it in court through the judge, of course, to the prosecutor.
Now, how's that working for you?
It's been pretty well. It actually has been pretty well.
Because on this argument of no personal jurisdiction?
On the observation, I hate this camera, on the observation that the prosecutor is based, almost his entire case is based on speculation. Well, we think the law applies because the law said so. And you just point out, well, that's a logical fallacy, that's circular logic, it's not evidence. And even like you said, it's not. In the idea, though, which I think is, I got to admit, I think it's pretty dishonest when we're talking about applying the law and not basing it on evidence. To put people in jail based on, we're going to apply our law, even though it's arbitrary, because we don't want the whole system to fall apart tomorrow. That's not a reason to destroy somebody's life.
Well, no, evidence is necessary to show that the facts of this case confer the personal jurisdiction.
The evidence to confer jurisdiction?
Yeah, it's necessary to have a factual basis in order to confer the jurisdiction. But the factual basis is this person was within this geographic area at the time the crime was committed and allegedly committed the crime. That's the basis for the personal jurisdiction argument. The personal jurisdiction concept is a legal concept, not a factual one. And so that law is dependent upon, that derives from either the nature of the Constitution or statute itself or case-made law over time conferring personal jurisdiction. So,
well, it still begs the question: how does your opinion as a judge, or any of these other judges who have made these decisions that the law applies, where are the facts that applies to me at all? Just because judges sit in Phoenix or D.C., just because a lawyer gives an opinion these laws apply to everybody, what evidence beyond your say-so is there to show it applies?
It's a legal conclusion, so it doesn't rely on evidence.
So
it relies on what the law is.
It's just an arbitrary decision.
Well, if you want to characterize all law as arbitrary, then that's fine. But again, I think your argument proves too much, because if that's right, if that's what you're saying, then no legal system can proceed.
Well, this particular legal system has no voluntary support. I mean, as a libertarian, you do agree that taxation is theft and that there's no voluntary support. The communities don't want it.
But again, we started by talking about whether or not there was error in conferring personal jurisdiction. We keep saying, where's the evidence that this Constitution applies to me, just because I'm standing here, you say. And I think I've answered that. And your counter-argument is, well, every time you talk about the law, that just sounds like somebody's arbitrary opinion. And I say to that, well, if that's true, and that were to be applied in court, then no one would be prosecuted for anything, and there'd be no legal system. And I don't know what your counter-argument is to that. Your counter-argument to that is that's fine.
Well, I think I agree with most of what you say. It's on.
And that's fine, but that's almost a political position, not a legal position to take inside the courtroom. Well, unless you believe that you're going to end up with judges who are going to buy into that and then just dismiss all the case.
Well, something about the judges buying into it is just a matter of holding a prosecutor to his burden of proof. Does he have anything more than pure speculation and...
No, all he has is an affidavit from somebody saying he saw this person in this location at the time that this crime was allegedly committed. That's all he's got.
Well, typically what they have that, like in Arizona, for example, I don't know if you've ever done traffic, the police officer is doing a certification that I believe the person named above committed the act that violated section XYZ of the code. So the police officer is determining that, one, the code applies to this guy. I have jurisdiction. Now, the question still goes to, and I think we've already answered it, that does the police officer have a personal first-hand knowledge of any evidence to prove the Constitution code apply? And I think you would agree that no, he doesn't. He just has what judges like yourself told him.
Yeah.
So when I say it's arbitrary, it's because it's based on his say-so, not any actual evidence connected to it.
Right, okay, we've gone through this before. He doesn't have any evidence offered on the issue of what law applies. That's a legal issue. That's up to the judge.
Well, I believe it. If you've got a legal argument that if it's not supported by evidence, then by definition it's arbitrary.
Well, again, the personal jurisdiction is supported by evidence in the sense that in a given state, in a given case, there has to be some evidence that the person actually was there. But you're challenging whether or not being there itself is in fact enough to confer personal jurisdiction.
Yeah.
That's a legal question, not a factual question. I don't know what kind of evidence that would be. What an affidavit from the founders of the Constitution? I don't know what
that's the whole point. The point why we're doing this is because there is no actual evidence. This is why I can go in and because what we're doing is uncovering a gun in the room, that they're imposing their laws arbitrarily at the point of a gun. And that's what we're bringing out.
I don't know what that would be any different than saying, well, you say I committed murder.
Wow.
Well, where's the evidence that the murder laws apply to me?
Well, that is different.
How?
One,
they have no evidence of that, you would say.
No, they don't have any evidence to
Well, they certainly would be with the gun and the body lying there, but where's the evidence that the murder laws apply to me?
There is no evidence that they do. But you do have evidence that that's the problem with having the compulsory system that we have now. That there are going to be certain arguments that you make like that to try to justify it. Well, let's destroy the lives of all these people if we can prosecute 0.5% of actual real crimes. But it still stands to reason that, or I think the point is that if all you can say for proof that the law applies is because we said so, well then, that's the point. That there is no evidence the laws apply. You just have a gang of criminals, co-government that are imposing it on everybody until enough people wake up and say, look, you have no evidence, and we're just not going to comply.
You would like Spooner's argument.
Absolutely.
The Constitution doesn't apply to anybody because you didn't agree to it.
Well, but the Constitution is 4 pieces of paper, and so it stands to reason. No.
Okay. Well, you should try that one.
Well, we have. Real quick, have you done any IRS cases?
I've never been involved either as a lawyer or as a judge. IRS cases are all in federal court. I was in state court for most of my career, and as a magistrate judge, I haven't had that opportunity.
So just if an IRS attorney, district counsel file a typical copy and paste petition to enforce an IRS summons, which is just a prayer for relief, would you be satisfied that they had filed a valid cause of action and had shown jurisdiction?
I don't know. I'd have to read it, but I don't know. I've never read one of these.
Okay, but if it was literally just a prayer for relief. He didn't give us this. We want an order compelling him to give us these books and records.
I don't even know the law in this area, so I don't know whether I couldn't even begin that.
Okay, I wish I had more time, but I do appreciate your time. Again, it was
No
John Buttrick, and you're
Sure.
a federal magistrate in Phoenix.
Right.
All right, excellent. Thank you very much.
Thank you.
I do.
Interesting. Right? The point being on the jurisdiction, a real crime, when there is actually a victim, there has been harm, and then judges can come in because there actually is a real crime done. With or without jurisdiction, it's just because there was harm done. That's just what you call natural law order, right? But because there is actually a victim, then the government really can step in and say, hey, you are not good with society, and we are here to go ahead and take you out and put you in a cage or worse. But everything else is minor, like these codes and statutes and all that. They're victimless crimes. Once again, a speeding ticket is a misdemeanor. Well, in the state of Texas, a misdemeanor is a crime. But how can it be a crime if there's no victim? Crimes have victims. No more, no less. So they're adding jurisdiction where there is no jurisdiction because no crime has been committed. No harm has been committed. This is for We the People News. Bye, y'all.